People of the State of Michigan versus Flynn Thompson. This is file 1822063. Mr. Thompson is here with Mr. Knopfsinger. And appearing by video, Mr. Gabriel is the prosecutor. And we're here today for the entry of a plea. The case was up yesterday, and we went through what the offer was going to be, and we indicated that it was going to be a no contest plea to one count of CSC in the second degree, and the prosecutor recommended the minimum sentence not exceed 1 year. They needed to file an amended information, and I needed the police report in order to review it to establish a factual basis, so we agreed to set it for today for a plea, and now we're here today for that. Is that correct, Mr. Gabriel?
It is, Your Honor, and the court does have an amended information which not only adds the count 10 of criminal sexual conduct in the second degree, but strikes the second offense notice. So the information that he's entering the plea of guilty to does not contain that information notice, but does contain the second degree charge.
Understood. Is that correct, Mr. Knopfsinger?
Yes.
So, Mr. Thompson, the offer is that you plead to one count of criminal sexual conduct in the second degree. And that is a felony and is punishable by up to 15 years in the Department of Correction. Mandatory AIDS, STD testing, and DNA was to have been taken upon arrest. They dismiss all the other charges, all the other supplements, everything else. And they also agree to recommend that your minimum sentence not exceed 1 year. Is that your understanding?
Yes, sir.
All right. And are you currently on probation or parole?
No.
Now, the difference between a no contest plea and a guilty plea is that in a guilty plea, you tell me what happened that makes you guilty of this offense. Mm-hmm. In a no contest plea, I get that information from some source other than you, such as the police report, transcripts, those kinds of things. Do you understand that's the difference?
Yes.
But a conviction, once I'm satisfied that there's a factual basis to accept it, the conviction enters just the same, the sentence is just the same as if you pled guilty. Do you understand that?
Well, they didn't understand that, but they do now.
Okay, do you want to talk to Mr. Knopfsinger about it?
Well, I guess we can talk for a few minutes. Yeah, sure.
Okay, so yeah, it's still, just as if you'd pled guilty to CSC in the second degree, you will be facing the same punishment and the conviction is just the same on your record. There's no little asterisk that says something like, but he pled no contest, as if it didn't happen. That's why I have to review the police report to assure myself that there's a factual basis that it did happen. So go ahead and talk with Mr. Knopfsinger about it. I'll put you into a breakout room.
Okay.
And we'll see you back here in a few minutes. Mr. Nafziger, you ready?
We are, Your Honor.
Any issues?
No, we talked about how the no contest plea will count as a conviction, and I think there was some confusion about that. But we're understanding that we are pleading no contest, and it will enter as a conviction, and we're prepared to proceed.
Okay, good. So you also understand that you'll be subject to the Sex Offender Registration Act also,
Yes.
right? And so with that, how do you, let's swear you in. Please raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Count 10 alleges a violation of criminal sexual conduct in the second degree, which indicates you did engage in sexual contact with a 14-year-old child under the following circumstances. The victim was at least 13, but less than 16 years of age, and defendant and victims were members of the same household. And that's a felony punishable by up to 15 years in the Department of Corrections and mandatory AIDS STD testing, DNA to have been taken upon arrest, and also is subject to the Sex Offender Registration Act. So how do you plead to that charge?
No contest.
Has anyone promised you anything other than what we've talked about in court today?
No.
May threaten you?
No.
Well, what was that hesitation about?
My wife has been real abusive towards me lately, and it's just my hesitation.
Okay, is she forcing you to do this?
No, she's not forcing me to do this, no.
Okay, are you doing this of your own free will?
Yes.
I just want to be clear, Your Honor. Is anyone threatening you to do this today?
No.
Okay.
Yeah, is anyone threatening you to take this plea?
No.
Okay, all right. And you're doing this of your own free will today?
Yes, sir.
And you understand that that the police report is going to be entered as a exhibit. It'll be used for a factual basis in the file, and also for sentencing purposes. You understand that?
Yes.
Okay. All right, so I have reviewed the Sturgis Police Department report. I've reviewed the transcripts of the interview. And it does appear that the victim does state that she had sexual contact with the defendant when she was between the ages of 13 and 16 in the summer and fall of 2017. and that they were members of the same household, and that several occurrences occurred of sexual contact between the two of them. That was the context. And again, the jury instructions indicate that a victim need not be corroborated by anyone else as long as there's a statement indicating that it did happen and the jury is the acceptance of it. With that, there is a factual basis contained in the police report for the allegation of one count of CSE in the second degree. Are counsel satisfied that taking the statement of the victim as put out in the police report would establish a basis for acceptance of a plea?
Yes, Your Honor, and I also want the court to be aware that I discussed this in detail with the victim in this matter as well as her father. We discussed all ramifications of resolving it in this way, and I'm confident that defense counsel also did so with his client, and the court has established a factual basis.
All right, Mr. Knopfsinger?
Yeah, thank you, Your Honor. I think the court mentioned that the report was from the Sturgis Police Department, but it may be sufficient, or that may be sufficient, but maybe a reference to establish venue.
Oh, yes, sir. It occurred in, I don't want to give the address, it occurred in the city of Sturgis, County of St. Joseph, State of Michigan.
Thank you, Your Honor.
Thank you. Are either counsel aware of any other promises, threats, or inducements?
No, Your Honor.
No,
And has the court complied with the court rule?
Court has.
the court has.
I find the plea made as knowing, understanding, voluntary, and there's a factual basis based on the admission of the police report and the transcripts. Therefore, I accept the plea. We'll set this for sentencing on June 4th. As we said yesterday, bond's immediately canceled and Mr. Thompson needs to report straight to the jail. And there at the jail, they'll give you a packet to fill out. You need to fill that out immediately so that we can do your pre-sentence report. And then the agent will be out to speak to you for the report. Okay?
Yes, sir.
Oh, you can't do the 4th, correct, Luke?
I don't know.
You said yesterday you couldn't. We were setting everything for the 18th.
Yes, the 18th will work.
Okay, the 18th. The 18th. All right, thank you. Okay, we are